rebuttal.
There are a few things that we have, and our integrity is one of them. For counsel to stand up here and call me unprofessional or inconsistent and making arguments that suit me in different cases is offensive, it's unconscionable, and I will only respond by saying, please do use our language, our drafting, our pleadings, and our argument on every single thing that we've ever said on this case or the parent's case, because the language is intentional and it's knowingly made. And it's known with the knowledge of what mental illness is and the definition of it versus, and I'll quote who was quoting me, the counsel, mental health issues, crisis, mental distress, and crisis. I'm not sure what would convince counsel or anyone, besides the testimony of a doctor, because I can bring 100 more to say the same thing. That is not the same thing as saying somebody has a mental illness that meets the statutory definition, which is what I am arguing, because that's the science, that's the data, and counsel knows it very well, which is why there's no insanity plea. So to stand here and say that I'm saying, and my team has said something inconsistent, is, first of all, ignorant and unprofessional. It is absolutely not true. And if the court needs more information, which would surprise me, but if the court needs more information between what mental illness means and the distinction between mental illness versus mental health issues, someone being in crisis, someone being in mental distress, someone being in crisis, by the way, could apply to all of us at one point in time in our lives. No one's going to argue that. That is what that's called. But the evidence and the data and the science do not show that he meets the statutory definition of mental illness, and that is what Dr. Anaker has testified to, because it's the truth. And this is not a legal insanity hearing. That plea was withdrawn. That defense was withdrawn. So, I agree. Mental distress, absolutely. Crisis, absolutely. Disturbing behavior, requests for help. Yes, I agree. We really don't disagree on very much, except I'm not lodging a false accusation and then trying to misstate the truth. Have not ever stated that he had a, quote, mental illness or that he did not. I don't know. I know and believe in the science. And I think counsel does too. That is why there was no insanity defense, because he doesn't meet the statutory definition of that, Your Honor. And I agree. All of this is mitigating. We really disagree on very little. What I am going to do is what I said I would do on the outset. I don't want to ignore any of that. You shouldn't ignore any of it. However, your job, pursuant to the case law, is to fashion an appropriate proportional sentence. And that, per the case law, is described as taking into consideration the Miller factors, every single one of them, and the offense and the offender. I, again, don't want to get too off track here, but the proper course to litigate when you're in trial is you put on a rebuttal witness based on the testimony of expert and the defense's case in chief. That's proper. That's what you're supposed to do, and that's what we did. We don't have the ability to call an expert and talk about rehabilitation, and it would not be proper, because we don't have the ability for that expert to actually evaluate the defendant as to that. So we did what is proper in these hearings, which is to respond to the testimony presented by the defense case in chief and what we felt needed to be cleared up, because some of it was just not credible. So let's talk about that. They called 4 experts, and I agree with nearly every word 3 of them said. I know that the juvenile brain is different, and I acknowledge it. I know that people who commit terrible crimes at 15 change over time, their brains do. And so why are we here, knowing all of that? Why did we make the decision, why did I make the decision to seek a life without parole sentence? I struggled with that for a long time. To be clear, I did not make a final decision about that position in the 21 days that the law allows us, where we have to give notice after a guilty plea. We did file notice and waited for a defense mitigation expert, because we don't have a right to get our own. Waited for a defense mitigation expert to tell us something about this crime we might not know, to tell us something about this defendant we might not know. And I didn't just wait for it, we actually tried to make it happen, because the first report that was given to me lacked serious mitigating factors that you should consider for the defendant. Didn't even include it. Did not have anything about the argument with his parents the night before. Did not have anything about what that thought process was and what was happening. Your Honor, there's a lot of people who would stand here and would never do that. And I have a problem with it, which is why I'm the prosecutor. But I believe in fairness and justice, and I believe that we should take very seriously a juvenile if we're asking for a life without parole sentence, and that the court must consider in circumstances like that. And it wasn't in their expert's report, and it was lacking. And there were also items in the report that weren't even true. So as an officer of the court, and also just being a person who morally feels that we have standards to live up to, I asked for him to include it, and he did. What did we get with Dr. King? We got a partly plagiarized report from someone who did not know the Miller factors. He focused on the wrong things. We learned that eggs break when you drop them, and implicit bias is real, but neither of those things have anything to do with your decision. I would note that there's not a single shred of evidence that this defendant suffered a brain injury, yet Dr. King basically his opinion is he probably has one. He didn't know how many minutes the shooting lasted. He didn't know how those kids died, and it didn't even seem like he cared. Dr. Anneker testified the objective known facts suggest the opposite of a brain injury. And in my effort to gather all that information, I also asked the defense to allow a prosecution expert to interview the defendant, and they refused, which is their right. So I was left with three things. I had Dr. King's report, which I do not believe is credible. I had Dr. Anneker's report, which thankfully was extremely thorough and balanced. I did rely on that and stand by her conclusion that he does not have a mental illness pursuant to the statutory requirement. And that's all I can say, and that's all she can say. But that doesn't mean he wasn't indeed experiencing a crisis. How can anyone say he wasn't in crisis? How can anyone say that he wasn't in mental distress? I agree. Consider it. It's mitigating. You should consider it. But you also have to fashion a proportional sentence. I sought out people and experts I knew might disagree with me. I asked people to disagree with me. I trusted them to tell me the truth, where that might lead. And in doing that, I learned that there has never been an offense or offender like this one, not just in our state, but our country. This is a person who killed 4 of his classmates solely for the pleasure of killing and to increase the body count to try to make himself famous. It wasn't impulsive, and their expert even acknowledges that. He didn't want anything from his victims, Your Honor. It wasn't settling a score. He didn't even know them. And the people he killed were also juveniles. Tate, Hannah, Madison, Justin. They had their whole lives in front of them. And in fact, that's his motivation. He wanted to kill people who had their whole life in front of them. And this is a person who, unlike any other, researched and planned how to survive the shooting to see his victims suffer. For this defendant who committed these offenses, and the way he thought it out and did it, life without parole is not a cruel or unusual punishment, which is what the 8th Amendment stands for. It's a just, proportional sentence. His life will be spared. His life will be spared just the way he wanted. He can continue to watch his victims suffer, but he can do it from a place where the victims will never have to live in fear that they will face him again, or that he will do it again to someone else. And even if the defendant changes and he finds some peace and some meaning in his life beyond torture and killing, does not mean that he ever gets the right to live free and among us. And that's not what Miller says either. Miller says you have to consider everything, and I want you to do that. And when you do that, this defendant should be sentenced to life without parole. This is a right and just proportional sentence. And lastly, there's another important point about the Miller decision. It avoided an absolute, Your Honor. It didn't say always or never. I listened to the oral argument in Miller many times, and that's what counsel for the defense was arguing for, an absolute line. The Supreme Court didn't do that. And I have found a lot of wisdom in that idea, both pursuant to this hearing and in all of the decisions I've made in my life, of avoiding absolutes. Because when you say always or never, a case will eventually come along that you didn't consider. And it did for me. You haven't heard me stand up here and call him a monster. I don't describe him in some inhumane way. I want and do allow the law to guide me. But I'm not going to shy away from these horrific facts and the evidence. And I know you won't either. Rarely, something very rarely, an exception comes along. And it did. And he's sitting a few feet from me. Please give him a life without parole sentence, Your Honor.